Let's go now to what's believed to be New Zealand's longest running criminal trial, which was aborted on Wednesday. The trial, which was initially sent out for 12 weeks, ended up trying a dozen lawyers and a High Court judge for 9 months, tying up Edward Gay, who's sitting beside me wondering what the hell I'm talking about. But it's now been scrapped because of breaches to the Criminal Disclosure Act, which requires the Crown to disclose relevant documents to the defence. Veteran criminal barrister Tony Bouchier, a former president of the Criminal Bar Association, gave an estimate of the costs involved in the trial to date.
It would be very difficult to estimate the costs. It's got to be a seven-figure sum. You've got not only the judge, court staff, the buildings, the prosecutors, the defence counsel, the witnesses. It's a trial that's been going for 9 months. It would be $1 million+ in costs to date.
Goodness gracious, our court reporter Edward Gay has been looking at the case and he joins us in the studio. Eddie, what can you tell us about the reason behind the trial being aborted?
Well, right now we only have the judge's oral judgment. Justice Wolford said that because these breaches happened after the Crown had finished giving their evidence and one of the defendants, the problem essentially couldn't be fixed. And he said that the trial may have had to have been put on hold for up to 2 months to iron these problems out. And that would have meant recalling witnesses. One of the defendants might have had to rerun his whole defence case. The judge said that he hopes to release his full decision by the end of next week in terms of the reasons behind this.
So then we'll know the reasons, but what happens now?
Well, we know that the case against the 4 executives of Viaduct Capital and Mutual Finance, it was expected to be the last prosecution against finance company executives. The 4 defendants, Paul Bublitz, Bruce Mackay, Richard Blackwood and Lance Morrison, they're due back in court in July. It's expected then the Crown may make a decision of whether or not they go again. Mr. Bublitz had originally faced 49 charges when the Crown opened back in August. By the time the trial was aborted, that had gone down to 13. Likewise, Mr. Mackay, he had been facing 41 charges. That had been whittled down to just 7. Lawyers are remaining tight-lipped involved in the case. They're not saying too much until the judge's full decision has been released. Mr. Bublitz's lawyer, Rachel Reid, she told me that Justice Wolford's full decision would say a lot more about the reasons behind this. And Greg Bradford, he represents Mr. Mackay. He said the legal team always believed the Crown's case was too broad, and he said the experience for his client had been devastating.
Gosh, this is fascinating. We've asked for costs. Who's asked for costs? What's happened here, Eddie? Because we heard Tony Bouchier speculating. What about costs?
Yeah, well, we've been to the Financial Markets Authority. They're the organisation who brought this prosecution. They won't comment. A spokesman said they're still considering the judgment. The Ministry of Justice said determining the costs would be complicated and they couldn't respond for our deadline. As well as the months of court time, there were 2 Crown lawyers, a lawyer from the FMA. There were 3 of the defendants had 8 lawyers between them, and there was an amicus appointed because one of the defendants was self-represented. So all up, there are 12 lawyers, and that obviously doesn't include the court time and everything else. But we don't know yet.
Fascinating. Edward Gay, thanks so much. Lots of different cases this week, Eddie, you've been sitting on, and we thank you for your coverage of them all. Have a great weekend.